Okay, let's go ahead and get started here. Welcome, everybody. Thank you so much for joining us today for our webinar series, Talking to Leaders in Legal. My name is Alex Sappington. I'm the CEO at PageVault and the moderator for our discussion today on this really important topic of digital evidence in intellectual property law. I'm here with two esteemed panelists. I'll have them introduce themselves in more detail shortly, but they are Marc Trachtenberg, an attorney at Greenberg, Traurig, and chair of the Internet, Domain Name, E-commerce, and Social Media Practice, and Wolfgram, who's an intellectual property litigator. A big thank you to both of you for being willing to share your knowledge and insights with us here today. So before we dive in, just wanted to take a moment and get to know our audience a little bit so we can keep the conversation particularly relevant for the group. So I have just a couple of poll questions for you. So the poll is going to pop up on your screen. The first question here, just let us know what your role is at your firm. Looks like the responses are rolling in here. So we'll go ahead and close out that question and flip over to our second and final question. Question number 2, how do you collect online evidence today? All right. Fantastic. Thank you, everybody. Looks like we have a really nice mix of roles and profiles here. Attorneys and paralegals being the most common in the room, but actually a sprinkling of every other category as well. And then for collection method, a lot of PageVault software, which is great to see, but also a lot of screenshots, a lot of print to PDF, and a handful of outsourced providers as well. So we really run the gamut here, which is great. I think it'll be a good conversation to just learn from these two folks here. So really what we're here today to talk about, I'll give a little bit of a preamble and then mostly turn it over to these two. So here today to talk about content that's found on the internet. So think about websites, social media, e-commerce platforms, and really how that content can be used in smart ways by intellectual property lawyers. So if you think back to where we were a little over a decade ago, Facebook was only a couple of years into allowing people beyond university students, whereas today, 81% of the United States actively uses social media with an average of 7 social media accounts per person. In 2010, the share of e-commerce sales of all retail sales was only 4.2%. Today, that's almost quadrupled to 15.4%. If you're a brand and you don't have a slick website, a Facebook, a LinkedIn, and maybe now even a TikTok profile, you're probably out there losing out to competitors. And so all this information has created a lot of complexity, but also really big opportunity in intellectual property law. The best IP law firms in the country have really figured out how to harness the power of all that content, collect it, preserve it in the right ways, and then leverage it appropriately to create better outcomes for their clients. And so we're thrilled today to have two leaders who have cracked the code on this, share some best practices and tips and tricks with us here today. So to start off, please just tell us a little bit more about yourself, your firm, and kind of areas of intellectual property that you focused on. And maybe Christian, we'll go ahead and start with you.
Yeah, thanks so much, Alex. My name is Wolfgram. I work for Banner Witcoff in our Chicago office. So mostly doing intellectual property litigation, patent, trademark, copyright, and that includes district court litigation as well as all the various proceedings in front of the Patent and Trademark Office.
Awesome. And Marc? I think you muted Marc.
I've only been using Zoom for 5 years now, and one day I'll figure out how it works. I'm Marc Trachtenberg. I'm with Greenberg, Traurig in their Chicago office, and I'm the chair of the firm's internet domain name, e-commerce, and social media practice. As the name of the practice group suggests, I deal primarily with online matters. So I do a fair amount of traditional soft IP work, but primarily it's focused on internet-related matters. So domain names, e-commerce, social media. We're constantly online, constantly taking screenshots, every day, all day long. It's critical to our practice. And a lot of what we do is related to intellectual property issues online, but not all of it. There's other issues as well, other types of offensive content and problematic issues online. But again, in all these situations, it's really critical for us to capture the content and the activity accurately, which is why we use Page Vault.
Awesome. Well, thank you both. Great introductions. And so to provide just a framework of today's discussion, we're going to cover three main topics. One, kind of when, why, and how online evidence is used in intellectual property law. Number two, the collection strategies and processes that you both use at your firm. And then number three, call it special topics, but some of the risks and challenges and other considerations that come up when collecting this type of evidence. And these topics all might blend together, so we won't follow it to a T, but we'll just have a good conversation here. So let's go ahead and dive in. My first question for each of you, and obviously it'll be different based on the types of cases you handle, but across all areas of IP law, where do you see online evidence being the most frequently relevant?
I guess I could start.
Yeah,
perfect.
Everywhere. Right. I mean, whatever you're alleging in any sort of claim, you need evidence. And, with online, the evidence generally is captured through screen capture. So, it's very critical to make sure that you're capturing evidence. And, depending on where you are, if you're on our website, not just the home page, you want to be capturing all the other pages, especially where there's content relevant to whatever your claims might be or whatever the issue might be. Same thing for social media. You don't want to just capture the profile. You want to go to the about area. You want to look at the posts. You want to capture all that information. So, it's just really critical all the time.
Yeah, certainly something we use in every facet of our practice across IP law. Though I would say on a volume basis, it certainly tends to be heavier in the trademark space. Naturally, that is about priority. It's about use. It's about third parties. It's about the defendant's use, the extent to which that their use is reaching out into the public's square. And so certainly, as we've worked with Page Vault, both having the software ourselves and working with them as a vendor on larger projects, I think trademark it's absolutely crucial.
Interesting. Yeah, trademark. It makes sense. That's pretty much all those trademarks are online these days, and so that's where you would need it the most heavily. Gotcha. Are there any kind of case examples, anonymized, of course, that you're able to share? Any stories of where something like this was particularly helpful or relevant to your case?
Yeah, absolutely. I mean, so we use it both as a sword and a shield. And we use it both in the, I guess you could say, in the moment of litigation and proactively. So if we're worried that, or we want to make sure that our clients' use of a trademark or their entry into a new space is really tightly and neatly captured. We're doing that work ahead of time, knowing that this might lead to litigation down the road. We have potential infringers we're worried about, or we're worried about kind of threading the needle in a tightly, in a crowded space. We're working proactively to capture use. Then in the moment, deadlines come up a lot faster than you think. And so we're certainly very narrowly or intentionally focused on capturing as much as we can and getting really creative with it. So, Marc mentioned the about pages and kind of understanding the background. But I think comments have been a really big source of evidence that we've used recently, showing actual confusion. showing, user or customers using trademarks in a certain way. It's basically a free survey. You can go out there and you can capture how people are interacting with a company or with a mark, and do that work without having to pay any expert, and then they get to opine on what they're seeing there. So I think those are two ways we've really used it.
Yeah, really interesting. And I like that point about doing it proactively. I definitely hear all the time, like, well, we don't, go to trial that often, and so we don't need to do this until we're, in the late stages of litigation. But interesting that you all are doing it so early in that process, before that litigation really even begins sometimes.
Right. Well, because we know that things are important, but the client is always concerned. They're business focused. So they might have an older part of their website that they're not as concerned with keeping up, or they might have, a certain look that they want to keep on the Instagram homepage and what their grid looks like and everything. And they're not thinking about the litigation impact, or either future or present. And so doing that work for them, being proactive, capturing what exists now to make sure that it's not just gone in the future. How many times have we gone online? Oh, where's that recipe that I used to use? I can't find it anywhere. I used to just Google it. Now it's filled with everything, all these other irrelevant recipes. So in a similar vein, we want to capture that so we always have it. And it's both for comprehensive litigation, but also for cost effectiveness. If we can be involved in one litigation, capture everything that exists now, how much better do we look to the client in the future when we say, you've already made the investment on capturing all this content, we have it saved for you, now we can use it again as a sword or a shield, quickly and very efficiently and quite cheap.
Very interesting. Marc, how about you? Any fun stories or case examples there?
In my practice, we use it proactively on the prosecution side, really mostly for specimens and things of that nature. I think, Christian definitely raises a lot of good points for how you can use it as a shield. Primarily, we're using it more as a sword. In the online space, generally we get notified of something, whether it's through an online brand protection service or monitoring service, or from the client or from a customer that reports it, or from an employee that reports it. And so the first thing we want to do is we want to investigate, we want to see what's going on, and we want to capture evidence. And it's critical to capture evidence at that time, because we don't know what it's going to look like even an hour later, right? A lot of these websites, social media pages, other platforms, very dynamic in their content. It may also, the content may vary depending on where you view it from. So, really critical to capture it immediately, because it's like, when you're traveling and you walk into that one store and you see the thing, you don't buy it, and you want to come back later, you can never find that store again. And it's the same thing with online evidence. If you don't capture it immediately, for whatever reason, it's never the same when you come back, almost never. And so you want to make sure that you do it immediately. You want to be thorough about it. You want to go, again, not just to the homepage, all over social media and the comments. And, you can do your investigation through, Page Vault or, whatever tool you're using to capture. And then as you're doing your investigation, you capture along the way. And again, I think that's pretty critical, because, investigation is kind of the same way. It's like walking through a maze. When you do an investigation, it's really hard to go back and rebranch and go back to that investigation. Just like when you review someone else's investigation, yours never really turns out exactly the same way, in part because of this dynamic nature of the content online. So just really critical to capture it, if you can capture it, chronologically and indicate that. So it's obvious to yourself and to other people when they go back and look at this evidence, what the steps were. That's very helpful as well. Examples, there's so many of them. We look at, hundreds of probably domains in a week, maybe more. We're capturing screenshot evidence of all of them. Even if there's no content there, that's relevant evidence as well. There's nothing there, you want to capture that. You want to capture everything. And it's nice that, Page Vault has metadata as well. So that's very useful. Otherwise, you have to separately capture metadata. You might have to get the source code for certain parts of the metadata, which just adds more steps and more time, especially when you're doing a high volume of enforcement. all these little steps, they start to really add up and cost more time. But every sort of issue that we deal with, we need to capture the evidence. Sometimes it's offensive content, right? And not just posts, but maybe video content. Maybe it's some compromising video of an executive or of a celebrity. Again, we want to capture that evidence, being able to capture the evidence on a certain site, having the metadata available to show that it's on that site, because it may be on a bunch of other sites as well. Also very helpful. And that's not just, the naked celebrity stuff, but, really all content. We find that a lot of infringing content spans across multiple sites and they all look very similar. So to have the ability to be able to easily demonstrate, which page the content is coming from and with what metadata, and then also to be able to show it's across multiple pages and have it be very clear and obvious that it's the same content across these multiple pages also is very helpful for, our enforcement efforts in telling that story to either the court or a platform.
Yeah, definitely. Fascinating. Which is, I think, a really good transition into, I'll call section 2, but the collection process overview, with maybe the first, just to kick it off, like, who is the audience that you all are collecting for? And it sounded like, Marc, you started to say it right at the end there. Some of the platforms, some of the agencies, but yeah, would love to expand on that a little bit more.
I mean, the courts, obviously, right? You need good evidence for the courts, and we can talk about that, and Christian will certainly talk more about it. But the platforms are increasingly resistant to abuse complaints. They have an incredibly high volume, and I'm not defending them, but it's just a reality. And so they're increasingly resistant, and they're starting to push back and ask for better evidence. As maybe they should, right? Because they get a lot of bad complaints too. So it's really important when you're submitting that complaint, not only to be as clear as possible in what you're saying in the complaint, but to have good evidence behind that complaint, and to have, a good screenshot that accurately captures the content, and have it be time and date stamped with metadata, really is very helpful for a lot of these platforms. They're going to continue to push back more and ask for more and more for us. They're asking for POAs now, and you just want to have all your ducks in a row, because when you have everything together and right the first time, they're more likely to process it and action your complaint. Whereas if you have to go back and forth, it tends to drag on forever. And I think, in court as well, and, Christian will talk more about this, but in court as well, I'm not a litigator, but I'm involved in a lot of litigations that go to court. And I can tell you that the judges are definitely pushing back more on evidence than they ever did before, pushing back on our claims, and they're pushing back on evidence. And you need to have your ducks in a row. You need to have clear evidence that's time and date stamped, again, that has the metadata, that looks professionally captured, to be able to have a court take you seriously.
Yeah, I think that's a good kind of transition. I think Marc nailed it, certainly with the kind of the black and white authority that Page Vault and other captures kind of provide. Is, what do the rules say? What do we need to show to get this to be admissible, right? So Marc touched on all that. I think another really important aspect of good, high quality, reliable captures is what you could call kind of the persuasive value that it holds. So obviously the courts are reading between the lines. They're, at the end of the day, they're human. So they have the law, they have the brief, but if you have misspellings, if you have bad punctuation, the court's not going to take you as seriously. And that certainly transfers over to exhibits and to capture. So if you're using low quality and kind of archaic means of capturing, whether they're intending to or not, they are absorbing that persuasive value, and you want it to have a beneficial persuasive value rather than something that's going to undermine your argument. So that, I think, is a key piece. And then not everything goes to final decision. If you can file a complaint and turn around and the defendant thinks you're, full of crap, well, you can produce right off the bat dozens, hundreds of captures over time, showing the metadata, showing the time and date, all of these things. You're going to go to settlement a lot quicker. And again, it has that persuasive value of, we're up against sophisticated, opposition. They have, what else do they have? If this is what they're giving me now, what else do they have, down the road? And it just tells me that, or hopefully tells them that they need to be thinking about business solutions now rather than getting mucked up in their defenses or claims.
Definitely, when you're relying on captures with Page Vault or a similar tool, and they're relying on the Internet Archive, that tells you something. It tells you something about your case. It tells a judge something, right? Mm-hmm. You have certainty. They have, well, maybe. You want to be in the certainty category.
Yeah, I have just to jump in there. I think on the Wayback Machine, because it's a tool we all use, and it still has value. But kind of back to your question about case examples, we had an example where we were asserting a series of patents, utility patents, and thought we had a really nice case. We were up against a very sophisticated firm, big distributor, and about 10 days after we served the complaint, we get an email with some captures from the Wayback Machine, essentially saying your patent is invalid. Look, you were selling this 18 months before you filed the patent. And when we first got that email, I mean, my heart sank because I thought, oh my, this is junior league. How did we not look into when the client first sold this patented product? Right. We go back to the client and we ask, when did this thing first go online? And the timeline, to make a long story short, essentially the timeline of their development, they had not even conceived of the idea or the need until 12 months after this alleged Wayback Machine capture showed the final product being sold on their website. And so essentially what we assume happened is that Wayback Machine, they kind of scan the internet every so often. And I think what they did is they used a newer picture for an older capture and just kind of pasted it on there. And so it looked like we were selling this product. It was an updated product, even though that's not at all what had happened. So we had to go do a lot of digging. We had to find emails. We had to show, the development of this product. We handed that over, and eventually that convinced the defendant that the Wayback Machine was wrong and that we were right. And it settled quickly thereafter, but it was a lot of time and expense and heartache spent on the fact that Wayback Machine was wrong. And I think a lot of us before that, at least here, took Wayback Machine to be Bible, and now understand that it is a human-made tool that has many, many flaws. And so if we can kind of, back to the proactive nature of how we take captures now, we don't want to rely on Wayback Machine to capture something we think is important now. We want to use Page Vault to capture it and make our own Wayback Machine in essence.
Wow. Yeah, that's really interesting. I can't tell you how many times we hear I have the Wayback Machine, so I'm going to be fine because I can just, I don't need to capture it before the case begins because the Wayback Machine's there for me. But yeah, that's scary that it's actually getting some things wrong.
That's really a tool of last resort. Because right. even when it gets right, it's not exactly right because you're not seeing everything that was on the page, and some links don't exist anymore or didn't exist when it was captured. And so it's a tool of last resort. It's where you go when you have nothing else and you say, okay, well, let me check there and see what it says. But right. I think those of us who deal in this area, we know it's not perfect. It's got flaws, and sometimes it's better than nothing. But again, if you're going to be in one or two buckets, you want to be in the bucket where you have Page Vault, or something similar, and not in the bucket when you're relying only on the Wayback Machine.
Right. Yeah, maybe the last point on the Wayback Machine, I have heard that you can actually ask the Wayback Machine to change things. So if there's something, you're not going to give the reason, but if there's something particularly incriminating, you can put in a request to Wayback and they will likely just go ahead and take that down. So there's definitely some unreliability there.
Oh, who's your contact there?
Perfect. So Wayback Machine we covered. That's very interesting. I'm interested, Christian, you mentioned a little bit about the kind of the rules of evidence, that admissibility side of evidence. How do you all think about that at Banner Witcoff? Like, when or why does this become a risk or a concern? And have you really seen this?
Yeah, I mean, certainly we have, and I think that all of us know that being as proactive as possible is the best policy. And so you're going to find yourself in deep water. Well, we'll deal with the admissibility later if it even gets to that, or if we end up having to file summary judgment, or whatever. And then now you're preparing your summary judgment brief, and you have a million other things to do other than worry about finding some way to authenticate a screen capture that was taken in a criminal case. And so we have the software in-house, where we have consistent people taking the captures, and they're kind of creating logs each day so that we can go back, and if we need them to write a declaration that kind of accompanies the page vault exhibits, we can do that effectively. And then to the extent we use Page Vault as a vendor to take the captures, we've certainly utilized the declaration option that you all provide. And again, that helps us just know, we're being proactive. We're taking care of this on the front end, so we don't have to try to worry about this on the back end when we're more preoccupied with the case law that we need to find and the evidence we need to cite.
Makes a ton of sense. Interesting. Yeah, I'll give the one kind of case example, and there's numerous here, but one of my favorites is a case called Disney v. Sorelli. Disney was suing Sorelli for trademark infringement on some of its characters, and submitted just pretty basic screenshots to the court. And the court actually struck that down, said this evidence is inadmissible because these screenshots are not very high quality and they're not authenticated right. There's an attorney declaration behind them, but it doesn't say exactly when it was captured, what the date and timestamp was, any of that critical metadata, as Marc was saying earlier, that's needed. And so therefore not properly authenticated, and we can't really look at these. And then the case pretty quickly fell apart after that. Can
I think
happen.
If I remember correctly, they were also like mobile screen captures, so like just take it on an iPhone or something. So again, goes back to the sophistication aspect. If the court is weighing whether I should allow this evidence or not, and it's a blown up iPhone screenshot that just has the time from the clock up in the right hand corner, what are you going to do with that versus Page Vault's cover page and all the associated metadata? I think certainly that could have been a toss up, and the judge 100% could have allowed that to go through. It's his discretion, her discretion. But I think that's where the persuasive value comes in, and who knows what could have happened otherwise.
Yeah, definitely. All right. Maybe taking a step back, Marc, to pull on a thread that you mentioned earlier, when you're essentially saying you're doing these captures while you're doing your investigation. Could you talk us through just who in your firm is actually creating captures? What is this workflow? What does this process look like? I think it'd be helpful for people to hear just kind of step by step from, hey, we know if there's something out there that we might want to go get. How do you actually do all of those different steps?
I mean, how it's used across the firm really varies differently, and by practice group, people are using it for different purposes. I think that, while I am not a litigator, as I mentioned earlier, I am involved in a lot of litigations, but beyond that, I don't know what's going to happen later with a lot of matters that I work on. Even if they're resolved informally now, anything can happen later, especially if connections are made later and you realize that, what you did earlier was part of a bigger network. And it becomes critical to have that evidence, captured back when you first investigated it. No one's going to remember. We look at, thousands or tens of thousands, maybe more domain names or, websites, social media platforms, listings every year or probably every month, right? So we can't, it's hard to remember what we saw, when we captured, what it looked like, where it directed. And so capturing that evidence in real time, really is critical. And so for me, I said, as I'm going through my investigation, I'll do the investigation in Page Vault. And as I go from screen to screen, I will capture the screens. I mean, generally, I will, instead of clicking on the link, I'll, right click to open a new tab with the link, so I can keep what I already have. And so then as I go across the screen in Page Vault, I kind of have a historical archive of where I just was. And that's kind of my breadcrumb trail for where I was. I mean, obviously, once you start getting pretty deep, that's not so efficient anymore. But, that's why I try to be careful when I capture to, either put things, in chronological order by putting a number at the end of the capture, or by naming the capture, based on the page, or a combination of both. If I want to capture what page it was, what specific page it was, and what order I went in. And of course, that information is captured in Page Vault, but I'm talking about in the title of the capture itself. I find that more efficient to, manipulate that and not just go with a domain name to guide myself. And then different people do it differently, in different practice groups. So the people that work with me, I have them use this method so that when I go back later and look at what they did, or if they leave, I can look back into Page Vault and see what was there and kind of follow it along the way that I would have done it. We make the tool available to really everybody in the firm, and we highly encourage them to use it for screen captures, for admissibility purposes and just for consistency purposes. Additionally, there's a huge benefit of having, the online repository to be able to go into. And so if everyone's storing all their data in there, even though it might be set different user accounts, if that person leaves or gets sick or, dies or who knows, whatever, that information is still there in Page Vault, which is under our subscription. So we have the ability to go to Page Vault and access that information and move it to a different account. So, that's absolutely huge. I think maybe this answers a question that somebody submitted earlier, which was what tool do you use? I use Page Vault because, my business is capturing screenshots, and I've tried pretty much every tool out there. I've used every method. I used Adobe for a long time. That was okay, for a time, when, courts and platforms weren't pushing back and websites weren't as complex as they are now. Now, if any of you try to capture a screenshot in Adobe, it never looks the same as it does on the screen. That's a huge problem. Accuracy is absolutely critical. You want to be able to say with certainty that what you're showing the court of the platform is exactly how it looked to the user when you captured it. Various, cutout tools, or you put it in Word and turn that into a PDF. Again, you lose all the metadata, and then now you have to make sure that you properly captured accurately when you capture the screenshot. Now you have to store it somewhere. And so, all these issues of not having accurate captures, not having the metadata, having to store it locally or, in some document management system, which is hard to navigate through. These are painful issues to deal with when you're capturing screenshots and relying on them all day long and all night long. And so to have confidence that you're accurately capturing the website or social media or listing as it appeared to the user, to have all the metadata, to have it be time and date stamped, to have an online repository that can be organized in a folder, hierarchy, just critical. It saves me, an uncountable number of hours per year, and the people I work for.
Definitely. Thank you, Marc. It's helpful. Christian, how about you all?
Yeah, it's certainly evolved over time, and I think it's been interesting because when I first started at Banner, I had to be introduced to Page Vault, and I think I was one of the first attorneys to know what that meant, what the program was, and what it did, and why we used it. And then fast forward to now, and we have dedicated paralegals who just take captures all day long. So we have attorneys that have the software and can use it, but just from a kind of client efficiency point of view, we found it's been really cost effective to have certain employees who are known throughout the firm as this is their job. First of all, they're good at it because Page Vault is a very powerful tool, but it has a lot of nuances. There's new features, especially Facebook pages that have been around a long time, or Twitter feeds that can just go on and on and on. There's certain ways that you have to kind of manipulate the tool in order to capture what you want. And so, whereas at first it was, I think our main two paralegals were the only ones that had accounts, then it got too big for them. So we hired one person to do it full time, and then that got to be too much. So we have two people doing it full time. And it's really evolved to be a cornerstone of what our litigation practice actually does. So we don't use the online repository quite as much. I think we tried to organize in our own kind of network folders where this is going, and kind of creating folder hierarchies similar to what Marc is saying, that are consistently labeled, consistently organized, so that no matter who is dropping in or dropping off of a matter or coming into a matter, they know if there's evidence, it should be here. Here's why I can go find it. And it's one of the ways that I get caught up to speed on a matter is what are the page vault captures that we've been taking, because it is directly proportional to what our interests and interests are in a case. And so I think that's one way we use it. And then we actually have kind of reminders that are set up. Is this something we need to capture every week, every month, every 2 months, to show either change or consistency over time? And so that's something that I know is something other people are using it for. And it'll be interesting to see how that evolves as we move forward. Kind of going back to the back machine of creating your own consistent, reliable repositories.
Right. Yeah, definitely. Yeah, I mean, hearing you guys talk about this, I think, Marc, maybe you said this in our pre-meeting, but there's having a tool and having the ability to do kind of the one-off capture as it comes up, and then there's having like a firm-wide philosophy and a process around this. Like, how did that develop for you all? Like, was this kind of spurred by one central person, maybe one of you at your firm? Was this kind of a natural, organic evolution? You realized, hey, this is actually making our companies, really effective and kind of leaders in this space, or how did that come about?
I mean, for me, I led the initiative in our firm. I mean, I deal captures all day long, and finding this tool was the best tool that I found. And I realized from working on, many cases with other attorneys and people in the firm, I'm called in all the time to consult on cases and give my view on, what the strategy should be, or what things mean. And time and time again, I saw either no evidence or, evidence that was captured in a way where I knew it was not admissible, or, it wasn't usable. It didn't tell me what I needed to know. And so I started evangelizing this. I got our subscription. I, had our group use it. Everyone in the IP group was, of course, on board. So that was pretty easy. I evangelized everybody, telling everybody downstream they should be using it. So all the partners having their associates use it for their captures. To Christian's point earlier, it's not really cost effective for the attorneys all the time to be sitting all day using Page Vault. If you're doing an investigation, it's one thing, but when you're capturing things on a regular basis, you need paralegals or dedicated people to use the tool, whose time costs a lot less for the client and for the firm. And so we started there in the IP group, but then we started pushing this out further to the firm generally. And I think there's no official policy, but it's generally well known that if you're going to be doing page captures, you're going to use Page Vault. And I mentioned on our pre-call, unfortunately, I am the admin of this tool now, which is the pinnacle of my career, being the Page Vault admin for Greenberg Traurig. But I think it's important, and I want to make sure that people have access quickly and they understand how to use it. And so I encourage them to read the tutorials and to contact you guys if they don't understand something, to make the most out of the tool. As Christian said, there's a lot of nuances, and if you're going to be using it, you might as well use it to its full potential so you can get all the benefits out of it.
Definitely.
Yeah. And I think it's evolved, as I said before. I think that it's certainly evolved as the volume has grown. I think it's also evolved just anecdotally as we've used both the software in-house and even more so Page Vault as a vendor in showing or talking about how we've leveraged y'all to do what seemed to be an insurmountable amount of work in a much, much shorter period of time. And you might change your whole case strategy based on what you think is possible to achieve. And so when we're able to talk to our colleagues about a struggle that they're having, or whatever, take a preliminary injunction motion. Those things move quick as lightning. And if you're on the defensive and you didn't know that that was coming, and you want to try to show just how broadly that your trademark has been used, you might just resort to wordplay if you didn't know that Page Vault was there to actually help you capture everything in a short period of time. And so through that anecdotal experience, I think it's permeated through our Chicago office, our DC office, and further.
It's a really good point. Yeah, you might not know what's possible until you've kind of experienced it, and all of a sudden the case strategy is a bit different. It's a bit more evolved. It's kind of more cutting edge.
Right.
Very interesting. You said the volume's gone up. I mean, this is maybe an obvious question, but how would you say the prevalence of kind of online evidence has changed over time? And do you think that's going to continue? Do you think that's slowing down? Where do you all see the kind of future trends in online evidence going from here?
Yeah, I mean, I think maybe if I ever get out of the law business, I'm going to get into the data storage business, because there's no way that that captures or online evidence or digital evidence is going anywhere but up. And so it's important to stay not just on, with the current trends, but be ahead of them. And so we've enjoyed working with Page Vault to make sure that we're amongst the leading edge of, like you said, what's possible, what's out there, and it's just going to grow. And so I think the next phase will be how you manage what you've captured, how you search through it, and then I don't know, we haven't had a conversation about this, Alex, but where does AI come into play in both the captures, but the identification of what needs to be captured? I think Marc probably could speak to that more, but when you're trying to play whack-a-mole with all of these potential infringers and, Amazon, marketplace infringers and everything, you can only fight against what you know. And so I think that's kind of where we're headed, is what is out there and how can we capture it and eventually take it down.
Really interesting. Marc, anything to add on with that one?
I think that those people who want to win are going to continue to rely on digital evidence and collect even more of it, because it's more and more critical. I mean, look, everything's moving online. We know that, right? There's not much brick and mortar anymore. There's not many people that are brick and mortar that don't have an online presence. So everything, is moving online. And that means that capturing digital evidence is more critical than ever. And so the trend will definitely continue. And I think Christian raises a lot of good points. The question will be how to manage that information, how to manage that data. Already, we're getting to a point where, we have a pretty big repository, and it's only going to continue to grow. And so at a certain point, the folder hierarchy is not going to be sufficient anymore. And so what do we do at that point? And I think that people need to start thinking about that, probably, including you, because as this trend continues and as the need to collect digital evidence becomes even more and more critical in almost every case, there's going to be a need to change how we store and find and search through that data and those captures.
Yeah, really interesting. Thank you for that. One more question, then I want to move to the wrap-up question. Do you think your two firms are unique in any way? Like the size, the scale? As I'm thinking, if somebody has, is a smaller IP practice, is digital evidence still important to them? Like, do they still need tools to be able to do that? Any thoughts on kind of how the size of your firm or the types of cases you're doing may affect your strategy here?
I think I kind of answered my last comment, which is that if you want to win, you're going to collect the evidence. I mean, the size of the firm is irrelevant. I mean, I think to some extent, the types of, matters you're working on is relevant. As Christian pointed out earlier, probably it's most useful in trademark type matters, but all sorts of other unfair competition, deceptive conduct, copyright issues, issues with offensive content. I mean, all these areas, it's absolutely critical to capture this evidence. It doesn't matter what size firm you are. And, frankly, Page Vault's affordable enough that if you're, going to be practicing law, you have expenses. I mean, this is a pretty minimal expense to to be spending money on when it's critical to the success of the matters that you're working on.
Yeah, I mean, you think of David versus Goliath, right? And that's oftentimes how we see some of these disputes, but whether it's the clients, whether it's the firms themselves. But what was the great equalizer for David was the tools at his disposal and how he used them. So I think that's how we try to think about it. We try to challenge ourselves and each other to, think innovatively, to litigate innovatively, and to continue learning about new tools that are out there. I think that's why we were an early adopter of Page Vault. I think that's why our practice has grown as Page Vault has grown. And it's certainly something that we intend on continuing to pursue.
Well, I think that to draw off Christian's analogy in David and Goliath, I mean, Page Vault can be the rock, because, if you're a small firm, you're generally representing a smaller client. On the other side is maybe a big company and a big firm. Well, we know that big companies aren't always very good about managing their information or managing their websites or capturing things. And so, they may think one thing, but the reality is different. And, that can be the rock that takes down Goliath when you have the evidence that's irrefutable about what was actually happening.
Yeah, I love that analogy. Fantastic. I don't think I said this earlier, but if anybody in the audience has questions for the panelists, feel free to throw them in the little button here that says Q&A. I'm going to ask a wrap-up question. Marc and Christian can comment on that as the questions from the audience pile in, and we'll get to any that we have time for. And if we don't have time for all of them, we'll definitely reach out afterwards to offer some answers there. So maybe closing question, if you could each just spend a couple of minutes here. Parting advice that you have for IP attorneys, paralegals, legal teams looking to effectively leverage on online content, and maybe what are some common mistakes that people should avoid, especially if they're kind of earlier in their journey of using this type of information effectively.
Yeah, maybe they're getting tired of hearing about it, but I think what we try to do is think proactively, act proactively. So what are you finding? What are your priorities? What are your challenges today, and how could those have been attacked yesterday, last week, last year? Let's start implementing that now. So if you're a patent prosecutor or a trademark prosecutor, how can we be capturing things now to prove use, to prove dissemination down the line? And if it's about a certain litigation that you're on and you capture a third of a client's content, why not just get the whole suite of it, so that down the road you can use that information proactively? Or if you're worried about someone who's kind of creeping towards you but not there yet, don't rely on Wayback Machine. Take your own captures now and share that story. I mean, I think of one of those little flip books that you have as a kid that you flip it and then the animation kind of goes through. When you can show change over time because you were proactive about taking these captures and collecting and sorting the evidence, it really opens up a lot of doors that if you hadn't taken those proactive steps, just wouldn't even be available to you in that present moment. So that's what we try to do. That's what I think Page Vault has allowed us to do. And we all get tied up in the priorities of this day and this week. But the more you can think ahead, the more you can be proactive. I think you're going to find a lot more success.
Thank you, Christian. Marc?
I think my parting advice would be to always over capture, not under capture. Unless you're against me, then you should under capture. but in other cases, I mean, I don't remember any situation where our problem was that we had, too much evidence against the other side, right? I'm not talking about discovery type situations, but we're collecting evidence. I don't remember when we had too much. It's always that we had too little. Why didn't we capture that other page? Like, why didn't we just go through, the information wasn't on the homepage, it was actually on this About Us page or the Contact Us page or like about the products page or something else. And, just over capture, try to capture, every page on the site. Of course, if it's a, site with 1,000 pages, that's not necessarily cost effective. It's not time effective. There's options to have Page Vault do it for you. That may not be cost effective depending on what your matter is, or time effective. And so, what I do a lot is, if I'm on a website that's not, 1,000 pages, if it's maybe, 15 or 20 pages, I will go through the site and I'll copy the links for each of the pages and each of the links themselves, and then I'll drop them into the bulk capture tool. And then I'll have it captured and then go on to the next thing, and then come back a little bit later and look at what's there, and then go through that evidence and, make sure that I have what I need from the site. And if not, maybe I'll go back and recapture something, or I'll look at something that, I didn't see or think to capture before. But again, then you have the whole site, and, the bad guys, they lie all the time, right? They're constantly lying. They're constantly changing things. They say, this wasn't there. There's nothing on the site. That wasn't on there. And, when you have that evidence, there's nowhere for them to go. And, again, that's why you want to over capture, because sometimes what they're saying is contradicted by something somewhere else on the site. And if you didn't go to the site and capture it, then, you're oftentimes out of luck, because, when you start making your claims, whether it's through a cease and desist or, through abuse complaint or something else, they're now on notice. They're going back and looking what's there, and they're making changes. And this goes back to my analogy earlier of, trying to find that store again where you saw that bag that you wanted. It's gone forever, right? You can't rely on the Wayback Machine because we probably didn't capture that day. So, my parting advice would be to always over capture, and then, to the extent possible, try to be as organized as possible in cataloging your captures. There's a folder hierarchy. You can use a lot of naming conventions, have everyone in the group agree on the naming conventions, have it be part of your process and your playbook. When new people come in, train them on it. The worst is if someone comes in new and they start capturing stuff and putting it all over the place, and then you can't find it. So, people aren't thinking about training people on page capture, as they're onboarding them, but it's critical. I mean, it's a critical, deciding factor in so many cases that, we try to tell people, almost day one, hey, when you're capturing evidence, this is how you do it.
Fantastic. Well, thank you both so much. Looks like we have a couple of questions from the audience. These actually, I think, are linked. But if any more, feel free to throw them in there, folks. The question here is, have you ever used awesome screenshots? And yeah, I think the question behind the question here is, hey, the owners and attorneys would need to approve the use of a Page Vault subscription, which is true. It's a paid tool, not a free tool. So I guess the question there is, are there any good free tools out there that you've seen? And maybe if the answer to that is no, how would you go about, trying to justify the ROI to an owner or an attorney at the firm who might have that budgetary power?
I have not used Awesome personally. Are there free tools out there? Yeah, they're frankly not that good. Like as I mentioned earlier, with the complexity of the sites that we're seeing a lot of times now, I don't find that most of those tools really are very good. Adobe, I used to use a lot. Now, when I capture in Adobe, it doesn't look anything like what I'm seeing on the screen. There's a few tools like, Fireshot that I think are pretty okay. There's a few others like that you can put in a browser tab. But, then you have the problem of, managing what you capture. So the capture itself looks more accurate, but you don't have the metadata. And, I would say that if my practice involved matters where screenshots were important, then I would find a way to justify the expense. And if you have clients, you can push it back to the clients. If not, you're investing other things like, having internet access and having Microsoft Office and other things. I mean, I view this as just as critical, again, assuming that your practice is, in these areas where screen captures are important. And if not, and it's a, very occasional thing, then, maybe it makes sense to use one of these other tools, but you're going to see when you're doing this on an everyday basis that it's definitely worth the cost, because you make it back exponentially, not only in the time that you save, but in the results that you get in the matters that you're working on. And I am not a paid spokesperson. Just a happy user.
Definitely. Yeah. I did not tell these folks to not ask these folks to gush so much. I appreciate it.
That's right. I mean, just to echo Marc, I think it's a win, not if situation. So, you'll either be grateful that you signed up, or you'll be ruin the day that you didn't. So I think that it's certainly been a key part of our practice, and another tool that's just as vital, as Marc's saying, as the internet or keeping the lights on or anything else. So yeah, we're excited to see what comes next.
Fantastic. Well, that brings us right to time. Thank you so much, both Marc and Christian. Really appreciate you joining us here today, sharing all these great insights with the group. Again, if anybody in the audience has further questions, feel free to reach out to me directly. Can pass questions along to these two if helpful. And yeah, thank you all so much for joining. Appreciate it. Have a great rest of the day.
Thanks, Alex.
Thanks, Alex.
Thanks, everybody.